Ready?
Yep.
State of Wisconsin versus Leonard Kachinsky, case number 2020 CM 489. Mr. Sordinsky, on behalf of the defendant who appears in person, Folger on behalf of the state, here today for a motion hearing. Where are we at?
Your Honor, this is contested. I do have some exhibits that I would like to present. Our position today is that information that was not included by the state in the complaint, but in the state's possession and knowledge, negate certain elements of the allegations. And my argument can be presented by testimony, or in this case, the parties are stipulating to the validity of these exhibits. I would propose just to walk the court through our position based on this evidence.
Any objection?
No objection.
Accept and receive the exhibits.
Oh. Len, defendant 6, 1 through 6.
Go ahead. Thank you, Your Honor. I direct the court's attention to Exhibit 1, and this is a copy of the order to extend the harassment injunction that is underlying the charges in 20 CM 489. I'd note for the court, first, you can see from the opening paragraph, the original harassment injunction was entered on June 29th of 2018, and would have expired then by the time of this incident, but was extended by this order. So this order specifically extended the original harassment injunction, and it's our position that it modified the terms of that injunction, and in paragraphs 4, 5, 6, and 7 provided the terms of the injunction going forward. So specifically, the terms of the injunction provided then under this extension was that the respondent is to cease harassment of the petitioner, have no contact with the petitioner. This shall include contact at petitioner's home, public places, or in person, and shall have no contact with the petitioner's family members. The document in number 7 specifically notes that the previous language allowed for work-related communications, and in this, pardon me, in paragraph 7, the court modifies that and eliminates that provision and simply says, as stated above, the respondent is to have no contact with the petitioner. I would note that nowhere in this order does it prohibit any third-party contact. It is direct contact that is prohibited under the...
Where does it say direct?
It doesn't say...
I'm looking at paragraph number 5, and I do not see the word direct.
But it does not say third-party contact either. It simply says no contact with the petitioner. So if he's not having contact himself, he's not violating that term.
Where does it say that it has to be contact by himself?
I think the court would, simply because it says it has no, the respondent shall have no contact with the petitioner. So a different individual having contact with the petitioner is not the respondent having contact with him. By the plain language of it, it's not including third-party contact.
Well, that's your argument. I think that's an issue for the jury to decide, though.
Okay, so on that first exhibit, I think that's an issue, and the petition or the criminal complaint does not include that. So I think the fact that the actual underlying injunction does not prohibit third-party contact negates that. Exhibit 2 is the original open records request regarding municipal citations. The criminal complaint is somewhat vague in its language to suggest that Mr. Kachinsky in his email that stated this just needed to be forwarded to MB was asking that an open records request regarding her work hours be forwarded. That's not accurate, and the open records request that he asked to be fulfilled is Exhibit 2. You can see on page 2 of Exhibit 2, number 5, he was requesting school bus citations. These citations can be fulfilled, and Mr. Kachinsky would testify to this fact, by either the municipal court or by the law enforcement agency, Fox Crossing. So nothing in that request requires Ms. Bartelt to comply or to reply to that. Exhibit 3 and 4 is the email exchange from Karen Bachman, the village clerk who was employed by Village of Fox Crossing, as the court can see by the address under her email, not by Fox Crossing Municipal Court. So two separate businesses within the Village of Fox Crossing. The exchange shows that she had a question about number 5 in Exhibit 2, which is the school bus citation. Mr. Kachinsky responded, the statute is 34638. That's halfway down on page 1. Included in this response, she provided what is Exhibit 4 to Mr. Kachinsky, showing that she had actually sent his response directly to Ms. Bartelt. So the email came back from Ms. Bachman, including Exhibit 4, that said, was an exchange showing that that's how Ms. Bachman addressed the open records request. The reason that's relevant is because that places the actual allegation of contact in context, and looking at what would be then Exhibit 5. Yes, Exhibit 5, which would be, this is the string of emails, and it's at the top of the page, it says Tim Seaver. The top email is just Chief Seaver forwarding the email chain to Jeff Sturgill. But if you'll follow below, the next email is from Karen Bachman back to Mr. Kachinsky regarding his open records request, where she does reply, including some of Ms. Bartelt's response. But on page 2, this is actually the basis of the state's allegation that he violated the restraining order. So this specific email is what the violation is based on, is that, and this begins at the top, from Len Kachinsky, sent April 19th, subject follow-up on school bus open records request. And it says, Dear Clerk, I sent the email below on April 5th. I know a lot has been going on, that this just needed to be forwarded to MB and ask her to send you copies of the citations. The email below is an email from Mr. Kachinsky to Ms. Bachman, where he explains that you appear to have forwarded the request to MB, who replied there was no records. So putting this statement in context, he's actually not directing anyone to contact MB, but is communicating with Ms. Bachman about the procedure she had already explained to him he had followed, and saying, I just need you to fulfill my records request. Nothing about that records request unto itself violates the restraining order or attempts contact. It's the email here where the extent of the direction to contact MB is this just needed to be forwarded to her. The final exhibit is the police report in this matter. I provide that to the court to show that on page 2, there's a summary of these emails, which shows essentially backing the version of events I have explained, which is support that the state was aware of these correspondence, aware of the exchange back and forth, and the fact that Ms. Bachman had already explained to Mr. Kachinsky that she was communicating with Ms. Bartelt, and so that his statement was not a go talk to her, but was a do what you've been doing and fulfill my open records request. So this is the basis of the violation, is this email, and I think in context, of these other elements, it is not a request for contact in the first place. I don't think the Exhibit 1, the harassment injunction, prohibits specifically third-party contact, but only contact by Mr. Kachinsky with the subject of the injunction. And in this case, he's not actually having contact with her. He's having contact with a different business in the same building, requesting her to comply with the procedure she explained she was doing to get open records request. There is a separate open records request mentioned in the complaint regarding the Ms. Bartel's hours. That record request, at least by these exchanges, was never forwarded to her, is not the basis of these allegations, and is not a violation of the restraining order. It was a request for information, and that based on the nature of the request, there was no need for Ms. Bartel to ever become aware of it, and Mr. Kachinsky had not at that point used it in any fashion that was a violation of the restraining order.
Anything, counsel?
From the state, other than we oppose this, we believe that the four corners of the complaint provide enough for probable cause, and I would note that in my review of the criminal complaint, I do reference the fact that this process by the village clerk to forward these open records requests to the victim was made known to the defendant back on March 27th. So I don't believe that there's been any evidence left out of the criminal complaint that would impact the validity of the charge.
Looking at the elements of the crime, first one, that there's a restraining order issued, that doesn't really apply because we know there has been one. Then the second issue is the defendant committed an act that violated the terms and conditions of the injunction. What counsel doing is arguing what it means, and there are different interpretations of it, and the court is not required to make a decision concerning which version of the facts is true or not. The issue becomes, could a jury decide that Mr. Kachinsky committed an act in violation of the terms of conjunction? Yes, they could, based upon the wording. As I was telling counsel when he was referencing the verbiage and the fact that what he was saying wasn't really what the restraining order said. Then we come thirdly to the defendant knew injunction had been issued and that his conduct would violate the terms of the injunction. The jury instruction goes on to say you cannot look into a person's mind to find knowledge. Knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon knowledge. Counsel continually stated we have to take this in context. I agree. With the context of the history involved here, I think a reasonable jury could find that there was a knowing violation of the restraining order, and I think the terms or the facts as set out in the complaint parrot that. Therefore, I would deny the motion.
For the record, Your Honor, I just ask that the exhibits provided, I believe it's 1 through 6, are stipulated to their validity, they be admitted to the record.
And no objection to that.
Once again, I'll accept and receive the exhibits. Do we have things scheduled in this already?
We do a final free trial on September 3rd, jury trial September 14th.
Fantastic. We'll see you then.
Your Honor, I guess before you go off the record, I don't know that we'll be at a place for jury trial at that point. Is the court using that as a hard and fast date or just keeping us on the move forward?
All my dates are hard and fast dates. It doesn't mean it's going to get tried that day because I have probably 10, 15 other jury trials scheduled that day that are hard and fast dates also.
Thank you, Your Honor. I just wanted to understand how the court's scheduled better, so I appreciate it.
I think we had about 69 cases scheduled a few weeks ago, and every single one of them resolved. And we had about 54 the next Tuesday, and every single one of those scheduled.